Okay, good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court. Today, I have read the probable cause affidavits and have made a determination, and each person will be addressed individually. When you come up today, I'll tell you whether I've determined probable cause, and then we will be able to talk about release conditions. Today is not your trial date, and so my advice to you is not to talk about your case on the record because everything in this courtroom is being recorded. For those of you represented by the attorneys from the Public Defender's Office, in the courtroom I do have the attorney Brian Reedy, and also over at the main jail, there's attorney Hector Romero. You can consult with them before speaking on the record. If you have private counsel, they'll come to the courtroom and we'll be able to address the court on your behalf. If your attorney is not here and you do have an attorney, you can let us know and we will see how we can accommodate that. But I'll be quick to say that if you have not retained an attorney for this arrest, chances are that they're not representing you for this case. And so please don't tell us that you have an attorney that you have not retained. Sometimes we make phone calls and then the attorneys say, we don't represent you because you have not been, they have not been retained for this arrest, okay? In the courtroom, we do have the state attorney's office represented by Mr. Eric Linder, and they'll be able to provide information to the court as well as confinement status and pretrial supervision, and we do have the clerk of courts to maintain the records. Before we begin, is there anyone that the jail has asked to be called out of turn?
No, Your Honor.
All right. Okay, so we will begin with Angela Amonte.
Hold on. Morning.
Good morning, Ms. Amonte. You are before the court on a misdemeanor capious matter. That charge is for petty theft.
Yes, ma'am.
It looks like you did not appear for your arraignment date on April 15th.
No,
So,
ma'am.
has anyone had a chance to speak with Ms. Amonte, and what does she wish
It's a
to?
municipal ordinance case, Judge.
It is? Has anyone heard from Mr. Shate today?
Not as of yet.
All right, Ms. Amonte, I'm going to recall your case when the attorney gets here, okay?
Okay.
All right, but, okay, we'll recall it when the attorney gets here. Emily Holbrook,
North Broward, Your Honor. How you doing?
good morning, I am well, happy Wednesday.
Happy Wednesday. Hi, Friday.
All right, Ms. Holbrook, you are before the court for resisting officer without violence, count two is trespassing, unoccupied structure or conveyance, and the court does find probable cause.
Ms. Holbrook indicated she'd like to resolve this matter today, Judge.
All right,
Offers adjudication time served on both counts, no return.
all right.
Is that what you'd like to do, Ms. Holbrook?
Yes, please.
Ma'am, do you understand the offer?
Yes, I do.
Okay, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, ma'am, you can put your hand down. Ms. Holbrook, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Right. Correct.
And have you ever been treated for mental or emotional illness?
Yes. Bipolar.
And is there anything about that illness today that would prevent you from making an intelligent decision?
No.
All right? And ma'am, you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes.
Okay, Ms. Holbrook, what plea do you wish to enter, guilty or no contest?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence, ma'am, is adjudication and time served. Good luck.
Thank you.
You're welcome. Shebra Stevens.
Municipal ordinance case, Judge.
That's a municipal ordinance.
Your name, Judge?
All right, Ms. Stevens, I'll recall your case when the attorney gets here, okay? Thank you.
Ms. Woods, come on up, please.
I'm sorry, yes, yes. And Ms. Woods' bond was posted? All right, so Savannah Woods, you're before the court. Count one is displaying another's driver's license, and then count two is resisting without violence. The court does find probable cause, and I've been
And nothing to add
advised
from the defense, Judge.
your bond has been posted,
Oh,
okay?
yep, I went through. Good luck.
Sorry, go home after.
Shanta Gooden,
North Broward, Your Honor.
North Broward.
all right, that's a municipal ordinance, Deputy. I'll recall it when Mr. Shake gets here. Thank you,
Okay.
thank
Just
you.
go ahead and back in cell one until the attorney gets here.
And then, Jacqueline Nebellini, there's a state.
North Broward.
There's a state
Municipal.
charge that's attached to that one.
Your Honor, she's a med reset though.
Okay. All right, Ms. Nebellini is a medical reset. And then Angela Bloodworth.
Call Ryan, Your Honor, she refused.
All right, I believe, Ms. Bloodworth, this is the second refusal, so I'm just going to proceed in making, probable cause finding. It's on a capias for a no-show at arraignment, and her bond is $500. Okay? All right, Courtney Taylor.
Call Ryan, Your Honor.
Good morning, Your Honor.
Good morning, Ms. Taylor. You are before the court. This is now two additional charges, charge 5 and 6. Charge 5 is, and both are for grand theft.
Yes.
All right. Do we know how much bond she's already in on the other counts?
I don't.
All right. All right. Okay. So the court does find probable cause, and I'll leave the bonds, $1,000 on each count, in place. All right, good luck, ma'am.
Thank you, ma'am.
Geralakia Atkins.
Ms. Atkins, come on up, please. She's here at Main Junction, approaching.
Ms. Atkins, you are before the court for, grand theft, and the court does find probable cause. I'll hear from the parties as to.
Not at this time, Judge.
All right. State, do you wish to be heard?
Oh, one moment, Your Honor.
Okay.
No, Judge.
All right, so Ms. Atkins' bond is $1,000.
Oh, Judge.
Yes.
I forgot that. Could confinement status see if her bond's been posted already? Sorry about that.
On Ms. Atkins?
Yeah, I knew I was supposed to ask. Sorry.
It's not showing yet.
Okay, don't be issue.
Okay. Emily Martinez?
Ms. Martinez is here present, Judge. I believe my colleague contacted, she has a private attorney, Judge.
Okay.
I can advise you as an officer of the court, I spoke to the prosecutor assigned to her case. She appeared before Judge Duffy yesterday. She was in court, she can confirm this, her attorney was contacted. Judge Duffy set the $10,000 bond back on her that you originally set, told her her bondsman can come in, file an affidavit to substitute, on the bond.
Right.
And the original GPS, pretrial GPS conditions that you had said.
Okay. All right. And, Mr. Reedy, was there any information from her private counsel that?
No, Your Honor.
All right. So, this is a change of charge, and so the court will, make,
I'm sorry,
yes.
I was trying to catch that to have it
Okay.
for the fact that the bond.
Okay, so the judge, her judge already reinstated the bond on this, okay? All right, good luck, ma'am. Jessica Spurlock,
Ms. Spurlock, come on up, please. She's approaching, Judge.
All right, Ms. Spurlock, you are before the court because you have an out-of-state felony hold, and it's a no bond hold out of the state of Texas. And so you will be going before the extradition court shortly, okay?
Good luck, ma'am.
Curtis Williams,
He posted his bond.
okay?
Bonded, Judge, if
All
anybody.
right, thank you. William Music,
North Broward.
Your Honor, that's North Broward. He refused.
all right, well, we'll just address it. It's an out-of-state felony hold, and he's got a no bond hold out of Georgia, and he should be going to extradition court shortly. All right, Eric Trigo,
Mr. Trigo, come on up.
all right, Mr. Trigo is before the court. Count one is touch or strike battery, domestic, and count two is felony violation of probation, which is a no bond hold, and Mr. Trigo does have court in his felony division tomorrow. The court does find probable cause. Does any party wish to be heard as to bond?
Yes, Your Honor. Your Honor, I'm going to be requesting a $10,000 bond, no victim contact. As you can see, he's on probation. He was placed on 5 years probation. He had a VOP and had his probation modified April 11th of this year. The victim of that strangulation is the same victim as in the case before the court, and one of his conditions of probation was to have no contact with her.
Okay,
Judge, considering as a no bond hold, I understand he only makes about $12 an hour, so I'm gonna be requesting a $2,000 bond on count one.
all right, the court does find probable cause. I'm imposing a $10,000 bond, no victim contact. All right. Deandra Williams,
Mr. Williams, come on up, please.
Mr. Williams is before the court. Count one is domestic battery by strangulation. Count two is felony battery domestic, and the court does find probable cause.
One moment, Your Honor. Your Honor, I'm going to be requesting a $10,000 bond on count one, $2,500 bond on count two. Mr. Williams, in 2013, was convicted in Dade County of attempted escape, aggravated assault, robbery by sudden snatching, and theft. He had a resisting with violence in 2012. He was sentenced concurrently on all charges to 1 year and 10 months in Florida State Prison. He was released in 2016. I'm showing. One moment. Nothing further, Judge.
Okay,
I don't see
Judge,
anything
12,000.
about
I'm sorry.
strangulation in this probable cause affidavit, Judge.
Yeah, that's fine, Your Honor. I request 24 hours.
okay. All right, the state has asked for 24 hours on count one. Gaetano Licata,
Mr. Licata is approaching, Judge.
Mr. Licata is before the court for aggravated battery causing bodily harm. The court does find probable cause.
One moment, Judge.
Sure.
Your Honor, I'm going to be requesting a $20,000 bond, pretrial release with a GPS monitor and no victim contact. I can tell you Mr. Licata was ordered. Just on, I'm sorry, previously, 1999 in the state of New Jersey, he was ordered, a protection order was issued protecting a different woman from Mr. Licata. I'm showing in the state of California, an arrest in 2005 for domestic violence battery that was dropped. In 2002, an arrest for domestic violence battery that was dropped. In New Jersey, 2014, loitering or prowling. 2014, possession of controlled substance. 2014, possession of controlled substance. 2013, ordinance violations, possession of controlled substance. 2011, manufacturing, distributing controlled substance. 95. Your Honor, I would also note, I'm also basing this on the injuries suffered by the alleged victim, noting when the officer arrived on the scene, she had to receive several staples to the back of her head due to the laceration that Mr. Licata caused. There was, let me see this, one moment. When the officer arrived at the scene, there was a large amount of blood coming from the back of her head, moderate amount of blood on the driveway. I would also note the victim appeared, from what she advised the arresting officer, she is in great concern, great fear of Mr. Licata.
The officer also felt it necessary to point out that the victim was intoxicated at the time that this happened, and how that may have contributed to her injuries or her perception or her recollection of the events that took place, I think is something the court can also take into account when determining appropriate pretrial release conditions.
Judge, the $20,000 bond, which is suggested, is something that Mr. Licata cannot possibly afford. He did advise me he's looking forward to disputing these allegations. I believe my colleague touched on it. He's basically disputing the way that the victim has portrayed how the events took place. Having said that, he's 55 years old. He's been here in our community now for about 5 years. I believe his most recent contacts have been minor municipal ordinance offenses. He was scheduled to start a new job today in roofing, where he believed or anticipated he could be making anywhere around like $60, $80 a day. Judge, I did advise him the court's going to order no contact. He's going to have to find a place. He doesn't know where, but he's going to have to find one, and he will be abiding by the court order as far as no contact with the victim. Judge, at this time, I'm going to be requesting a $4,000 bond on his behalf, Judge.
I would just note, if, as the defense is arguing, if this was accidental or caused by the victim's own state, Mr. Licata fled from the scene before police could arrive.
Okay, the court finding probable cause and imposing a bond of $10,000, no victim contact, and also that's going to include level 2 GPS. Okay. Sean Dorsey.
Mr. Dorsey, come on up, please.
So Dorsey is before the court for count 1 is violation of felony probation, and count 2 is a misdemeanor KPS. Count 1 is a no bond hold, and Mr. Dorsey will be before his felony judge tomorrow. Count 2 on the KPS is a municipal ordinance violation.
Just ask that that goes to the division judge.
All right, and so. Okay. All right, so he'll be in court tomorrow, okay? Michael Lawson,
Conti, Your Honor.
I'm sorry, what was that, Mr. Reedy? Okay. All right.
Your Honor, I apologize. I was not able to get to this case beforehand to give you this, to provide the court with the paperwork. Obviously, I would have if I was able to.
All right. So then we'll recall Mr. Lawson towards the, well, I'll leave it for the end because I have a few things that I have to go read. All right? Okay. Philo Little.
Who's approaching, Judge? Good morning.
Good morning. Mr. Little is before the court for a traffic capias matter. And looks like this is a charge for operating without valid license. Mr. Little did not show for arraignment on February 19th of 2018, is what the capias says. So what does Mr. Little wish to do?
Judge, it's me, Mr. Little. He wishes to resolve this matter today.
Okay?
One moment, Judge. Offers withholding court costs.
Okay?
Judge, he wishes to accept its offer.
Okay, Mr. Little, do you need any more time to speak with your attorney? Okay, sir, please raise your right hand. Do you swear or affirm to tell the truth? Okay, you can put your hand down. Mr. Little, is anyone forcing you to resolve your case today?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand that you have a right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
I understand.
Okay, well then what plea do you wish to enter, sir? Guilty or no contest? What was that?
No contest?
All right, I accept your no contest plea. Find that it's freely and voluntarily given, and your sentences withhold adjudication and court costs. Good luck, sir. Eddie Wright,
North Broward, Your Honor.
thank you. All right, Mr. Wright, you have a misdemeanor capias on a municipal ordinance violation. The court does find probable cause. Looks like you did not show up for arraignment last year, June 14th. So, yeah.
Judge, the offer would be time served for Mr. Wright.
All right, so Mr. Wright, if you wish to resolve your case today, the city is offering adjudication and time served to resolve your case. Do you wish to do that, sir?
Yes, ma'am.
All right, then please raise your right hand. Do you swear? That's okay, that's the right one now. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. All right, Mr. Wright, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with the attorney?
No.
And sir, you understand that you have a right to go to trial, but by taking a plea today, you are giving up that right.
You lost me there.
Okay, so what I'm saying is that you don't have to take a plea today. If you want to go to trial, you can do that. But if you
No, I
take,
don't want to.
okay,
I don't want
but,
to go.
all right, so then let me finish. But if you take a plea today, it means that you're giving up, you're waiving your right to go to trial. Do you understand that?
I don't want to go to trial.
All right, okay. And so, and have you ever been treated for mental or emotional illness?
No.
And sir, you understand that if you're not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes.
Yeah.
All right, then what plea do you wish to enter, sir? Guilty or no contest?
Guilty.
All right, I accept your guilty plea, find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck.
Okay.
All right. Nicolasu Arends.
He's approaching, Judge. He's here at me.
All right, Mr. Arends is before the court on a touch or strike battery, and count two is possession of cannabis 20 grams or less, and the court does find probable cause.
Judge, we're going to be asking the court to consider releasing Mr. Arendis on pre-trial release. My understanding is, and he advised me he's never been arrested or anything similar to this. He's currently looking for work. He lives in Sunrise with his mother. They've been residing in the same location for about 1 year. He says financially he cannot afford to post the bond. So we're asking for the court to consider releasing him on pre-trial release.
One moment, Your Honor. I have no objection to pretrial. We'll just request an order of no victim contact and no return to this location at 10131 West Oakland Park Boulevard in Sunrise. Looks like a Publix.
Okay. All right, Mr. Arends, the court, I am going to release you to pretrial supervision. The attorney will hand you the information, and you need to report within 24 hours of your release. Failure to do so will result in a warrant being issued for your arrest. Second, no victim contact, and third, no return to that Publix. Do you understand that, sir?
Answer, I'll answer.
All right.
Yes, ma'am.
Okay. Don Royster.
North Broward, Your Honor.
All right, Mr. Royster is before the court for trespassing and petty theft. And the court does find probable cause.
I believe Mr. Royster would like to resolve this matter today, Judge.
All right, Mr. Royster, your attorney tells me you want to resolve your case today. Is that correct?
Yeah.
Your Honor, the offer to resolve both matters would be adjudication 5 days in county jail. Mr. Royster's been through here many times, mostly low level, but it adds up. Lots of trespassing, 2017 battery on a public transit employee, disorderly intoxication, resisting without violence, trespass, theft.
When was the last time
January of this year, he had a trespass.
for a trespass?
We'd invite the court into the negotiations to see if the court would offer Mr. Royster time served.
And what was this location where he was? Is it, oh, Quick Stop, I see.
And frankly, Your Honor, the offer has more to do with the theft than the trespass. It's, and I'm not condoning either, but it's one thing going into stores, someone take some food, but now he's stealing someone's personal property, breaking a bike lock, stealing someone's bike. Actually, it was unlocked, but still.
I'm sorry, what was that last
Said
name?
it was unlocked, but even so.
Okay. All right, Mr. Royster, if you wish to resolve your case today, the sentence will be adjudication and time served. Do you wish to do that, sir?
Yeah.
All right. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Royster, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, you understand that you have a right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes, ma'am.
What plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. And also, sir, that's coming with an order, no return to the quick stop store. Is it the same location on both?
No.
And,
The other was
The other one.
Physical therapy business, I believe.
okay, so no return to these businesses. Do you understand that?
Yes, ma'am.
All right, good luck.
All right.
All right, one more and then we'll do Mr. Shade. Fabian Ayala. That will be all the DV, I think.
Mr. Yall is approaching you, Judge, you see what it means?
All right, Mr. Ayala is before the court for touch or strike battery. And the court does find probable cause.
Judge, nothing to add at this time.
Okay. I'm never sure. Does the state wish to be heard?
Oh, no, Your Honor.
Okay, so Mr. Ayala's bond is $1,000.
I'll call your girlfriend right after.
Okay.
Good luck, sir.
Not in front of the.
All right, I'll call a few of Mr. Shade's cases.
Eric Roberts, sit right there.
On page 1,
Some of these might be
Angela Amonte.
this one.
I think she was at North Broward.
Paul Ryan, Your Honor.
Oh, Paul Ryan. All right, Ms. Amonte. All right, Ms. Amonte, the attorney's here now, so we can address your case.
Okay, ma'am.
There is a municipal ordinance violation. There's a capias that was issued on April 15th because you did not appear for arraignment. And
Yes, ma'am.
so what do you wish to do with your case today?
Resolve it, please.
All right.
Time served, Judge.
All right, so I've been informed that the offer from the city is time served.
Okay, thank you.
Okay, so please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Ms. Amonte, you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
And is there anything, are you under any treatment, or is there anything about that illness that would prevent you from making an intelligent decision today?
No, ma'am.
And ma'am, you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes, ma'am.
Then what plea do you wish to enter, Ms. Amonte?
No content.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck.
Thank you.
All right, and then Shebra Stevens. All right, Ms. Stevens is before the court on a misdemeanor capias, on an alcoholic beverage violation, and you did not show up for your arraignment on April 29th. So the court does find probable cause.
Same thing, Judge, two time served offer to
All right, Ms. Stevens, what do you wish to do today? Ms. Stevens, can you hear me?
Yes, ma'am.
Okay, so what do you wish to do with your case today?
I want to resolve it.
All right, the offer from the city is adjudication and time served. Do you want to accept that offer?
Yes, ma'am.
Okay, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And Ms. Stevens, do you understand everything that's going on here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with the attorney?
No, Your Honor.
And you understand that you do have a right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes.
Then what plea do you wish to enter, Ms. Stevens?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence, ma'am, is adjudication and time served. Good luck.
Thank you.
On page 2, Shanta Gooden.
she's no,
North Broward, Your Honor.
Thank you. Ms. Gooden is before the court on a misdemeanor capias. Ms. Gooden, the capias was issued because you did not appear for arraignment on March 22nd, and the charges solicitation or panhandling. What does Ms. Gooden wish to do today?
she'd like to resolve the matter, Judge, it'd be a time served offer.
All right, Ms. Gooden, do you understand that offer?
Yes, ma'am.
All right, and is that what you wish to do today?
Yes, ma'am.
Okay, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Ms. Gooden, do you need any more time to speak with the attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
You understand you have a right to go to trial, but by taking a plea today, you are giving up that right.
Yes, Your Honor.
And have you ever been treated for mental or emotional illness?
No, Your Honor.
And you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes, Your Honor.
What plea do you wish to enter, ma'am?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck.
Thank you, Your Honor.
You're welcome. And then on page 12, Mark Valerine.
Judge, it'd be the medical reset.
Mr. Valerine is a medical reset.
It's in North Broward.
Is that North? Right?
He's here in
Oh, he's
main
there.
jail, Your Honor.
Okay. So, Mr. Valerine,
Oh, I'm sorry, Judge, I thought we were doing that. I'm sorry.
what was that?
That's okay, I thought we were doing somebody different.
Okay. Mr. Valerine, you are before the court today for a misdemeanor capias matter for an open container. Sir, do you understand?
Yes.
Okay. And so what is the offer for Mr. Valerine?
It'd be time served.
So, Mr. Valerine, if you wish to resolve your case today, your sentence will be adjudication and time served. Do you wish to do that, sir?
Yes, ma'am.
Okay, sir, please raise your right hand. You swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Mr. Valerine, you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Do you need any more time to speak with the attorney?
No.
Are you under the influence of drugs or alcohol?
No.
Sir, you understand that you have a right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for mental or emotional illness?
No.
And sir, you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes.
What plea do you wish to enter, sir?
No
Guilty?
contest.
Okay, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir.
Okay.
On page 13, Jonathan Marion.
Judge, I'm sorry, I apologize. What did you call?
Jonathan Marion. On
Mr.
page
Marion?
13.
14?
13.
13.
Oh, 13.
Yes, ma'am.
He's approaching, Judge.
Okay. So, Mr. Marion, you are before the court on 3 misdemeanor capious municipal ordinance violation matters. And all 3 of them are for trespassing. Okay, so what do you wish to do today, sir?
I'd like to resolve it, man.
All right.
Judge, there are 3 old cases coming out of 2018. He doesn't really have any history with the city that we're aware of, and it's often time served.
All right, so Mr. Marion, if you wish to resolve your case today, the sentence will be adjudication and time served.
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Mr. Marion, you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Do you need any more time to speak with the attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes, ma'am.
All right, what plea do you wish to enter, sir?
Excuse me?
What plea do you wish to enter?
Guilty.
All
I
right.
mean, no contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given.
Well, same thing.
Your sentence is adjudication and time served.
Okay, thank you, ma'am.
All right, you're welcome. Michael Humanes on page 13.
Medical reset.
Okay. And then John Ferguson on page 14.
Mr. Ferguson, come on up, please.
All right, Mr. Ferguson, you are before the court. It's on a misdemeanor capious matter on a municipal ordinance violation for trespassing, and the court does find probable cause. Mr. Ferguson, what do you want to do today?
Solve it.
Every time served.
All right, Mr. Ferguson, if you want to resolve your case today, the sentence will be adjudication and time served.
All right, thank you.
All right, please raise your right hand.
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down, Mr. Ferguson. Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes, ma'am.
What plea do you wish to enter, Mr. Ferguson?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence is adjudication, time served. Good luck, sir.
Thank you.
All right. And then Eric Roberts,
So that's,
I think that's it, Mr.
That's
Shadefree.
it.
Yes.
Thank you.
All right.
Eric, that's your case. Eric Roberts.
All right, Mr. Roberts, you are before the court for assault on officer, firefighter, or EMT personnel. The court does find probable cause.
Nothing to add by the defense, Judge.
All right. Then, Mr. Roberts, your bond is $100, sir. Good luck.
Good luck, sir.
Lizanne Campesco,
Mr.
Camsico.
Kemseko, come on up, please. Kemseko. He's approaching, Judge. He's here at me. Right here.
Mr. Camseco is before the court. Count 1 is possession of drug paraphernalia, and count 2 is trespassing. And the court does find probable cause.
Judge, I'm going to be requesting that the court consider releasing Mr. Kemseko either ROR or on pretrial release. He's 28 years old. He is working right now. He works in construction. He lives in Pompano Beach, where he's been renting out for the past 6 years, and his rent is approximately $600. Considering these are non-violent offenses, that's why I'm asking the court to consider releasing him ROR or in the alternative on pretrial release.
Fine with an ROR, Judge.
All right, so Mr. Camseco will be released ROR.
Ask for an order of no return.
And what is this location now again?
Express Food Store at 540 West Sample Road in Pompano Beach.
Do you understand that, sir? You cannot go back to that store. Okay?
Yes, sir.
All right. Robert Jacobs.
Come on, sir. He's approaching, Judge.
Steve. This guy's got an MO. Jackus.
All right, sir, you are before the court for obstruction by disguised person, and count 2 is a municipal ordinance violation. It's
JACUS.
being in the park after hours is the municipal ordinance violation. So the court does find probable cause.
Judge, in speaking with Mr. Jacobs, he wishes to resolve this matter, sir.
Okay,
On count 1, the offer's time served.
all right.
Judge, he wishes to. Speak to him.
All right, so Mr. Jacobs, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. Sir, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
And sir, have you ever been treated for mental or emotional illness?
No, ma'am.
And you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
Yes, ma'am.
Then what plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence for both counts is adjudication and time served. Good luck, sir.
Yes, ma'am.
Sean Burgess.
Mr. Burgess, come on up, please.
Mr. Burgess, you're before the court. Count 1 is operating without a valid driver's license. And then count 2 is a traffic infraction not for magistrate, and the court does find probable cause. What does Mr. Burgess wish to do?
Judge, Mr. Burgess did advise me he's trying to get his license straightened out, Judge. I'm gonna ask the court to consider an ROR on Mr. Burgess' behalf.
He doesn't have a license to get straightened out. He's never had a driver's license. He's driving on a revoked, on an ID card where his driving privileges have previously been revoked.
All right, so Mr. Burgess, your bond is $25. Brenton Malone,
Mr. Malone, come on up, please. Mr. Malone, come on up, please. He's approaching, Judge.
Mr. Malone, you're before the court for trespassing charge, and the court does find probable cause.
Judge, I'm going to be asking the court to consider an ROR on his behalf. I'll see if the state has an objection before I proceed.
Your Honor, he has no record. Frankly, my only concern is, and I don't know if Mr. Malone needs assistance. Apparently, this is the second time he's trespassing at this community center. This was at about 11:15 last night.
All right,
Judge, I did advise Mr. Malone, he's not going to be going back there. He's going to be having his day in court, Judge, as you heard, he has no prior record. That's why I'm asking on this nonviolent charge for him to be released ROR.
well, I'll ROR Mr. Malone, but I'll also let him know that he cannot go back to this park. And if Mr. Malone needs to seek assistance for living or something, he needs to try and work on that, okay?
Yes, Judge.
All right. Tavion Gibson,
Mr. Gibson, come on up, please. Good morning.
good morning. Mr. Gibson is before the court for possession of cannabis 20 grams or less, and count two is possession of drug paraphernalia. And the court does find probable cause.
Judge, we're going to be requesting an ROR on Mr. Gibson's behalf. I'll see if the state has an objection before I proceed.
All right, Mr. Gibson will be ROR'd on this charge, and sir, you need to make sure you pay attention to your mail so you know when you have to come back to court, okay? All right, Deville Young,
Your Honor?
yes,
Before we get to that, I noticed on the page before in the docket,
yeah,
there's a Latourus Fort who says he's been reset from Monday and Tuesday's dockets. It's a no bond VOP, so I don't know why he keeps getting reset for our docket.
and I don't, so I don't go by the docket, so I
Yeah,
don't
no.
have any paperwork
Yeah,
for that.
that's why I think you don't have the paperwork, because it's a VOP, but he's on page 16 of the docket.
Okay,
I don't know if you just, if the court would be inclined to ask the clerk, just make sure he's not reset for us.
all right, Madam Clerk, you have,
No, he was sent, that's Judge Pohl. I know that's what it says, but it also says reset from 5-6 and 5-7. I imagine if we don't do anything, he's gonna get reset for 5-9.
Madam Clerk, you have that on your docket? So that we don't reset it again for first appearance? Thank you. All right, Deville Young.
Case here, present, Judge Amin.
All right, Mr. Young, you are before the court for some additional charges, 6, 7, and 8. So 6 is carjacking with firearm or weapon. 7 is aggravated battery on an officer. Count 8 is aggravated fleeing with injury or damage.
Your Honor, Mr. Young was arrested April 17th on these charges and appeared before Your Honor on the original probable cause affidavit on the 18th. You found proof evident presumption great, but set a bond on the carjacking at $150,000, a bond on the aggravated battery at $50,000. The fleeing and eluding we changed a charge on a not in custody, which this is a not in custody information. You originally set it at $2,500 for that corresponding charge. Your Honor, what happened was 2 days before he was brought here from Dade County, the state filed this not in custody information. And I've already notified my office. What we're gonna end up doing is no infoing the case that you heard on the 18th. Because these are the same exact charges, I'm going to ask the court to set the same bonds and conditions that you set previously.
Okay. All right.
And Judge, I understand what Mr. Leonard said, and as you can see, he's been in custody this whole time, and I mean, $200,000 is just something that that can't afford.
All right. Well, the allegations have not changed, so I am going to just reimpose the bonds that were previously in place.
It was 150, 50, and 2,500 with a pre-trial release on the GPS monitor.
Okay.
I'm sorry? 150,000 on the carjacking, charge number 6. 50,000 on the aggravated battery, charge 7. 2,500 on the aggravated fleeing, charge 8.
Is it a level 2 GPS?
I believe so. Let me check that. No, Your Honor, it was a level 1.
Okay. Look, sir. Alberto Gomez.
North Broward, Your Honor.
All right, Mr. Gomez, you are before the court also for additional charges, starting with charge number 5, grand theft. 6 is a felony violation of probation, which does have a no bond hold. 7 is violation of probation with a no bond hold. 8 is grand theft. 9 is violation of probation, no bond hold. 10, violation of probation, no bond hold. The court does find probable cause, and you are scheduled to be before your felony judge tomorrow at 8:30, and the standard bonds on the other counts will remain, okay?
Your Honor,
Yes, sir.
can I ask you what are they accusing me of?
I just told you.
Yeah, grand theft, but what did I do?
I don't have a copy of the new probable cause
All right,
affidavit, Judge.
there are 2 police reports. On April 18th, they are alleging that you went into a store and took a Craftsman inverter value of $999.99. You put in a shopping cart and then walked out of the store. And then on the following day, they are alleging that you went to the store, took another Craftsman inverter, walked out of the store. That's what you're being charged with. Okay? All right, Michael Mancini.
He's here, present, Judge, and May.
Mr. Mancini, you're before the court on additional charges. Charge number 2 is grand theft, and number 3 is resisting without violence. And the court does find probable cause.
Judge, and speaking of Mr. Mancini, I did advise me as add charges of grand theft resisting. We just want to know when is the date of offense. I believe he's being held no bond on count 1.
April 10th from Publix. All right, and I'll leave the standard bonds in place on 2 and 3. Trey Howard.
He's approaching, Judge. He's here at Maine. Mr. Howard?
Mr. Howard is before the court on a burglary, unoccupied conveyance, unarmed, and the court does find probable cause.
Ebony Rocio for the state, Your Honor.
Good morning.
Good morning. Your Honor, the state is asking for a bond amount of $1,000. and no return to the Seminole Indian Reservation.
Judge, I'm going to be asking for the court to consider a straight ROR or in the alternative, what the state has suggested, $1,000. My understanding, Mr. Howard, he has a clean record. He's been here his whole entire life. He's 19 years old. At this time, he's currently looking for employment. He obtained his GED. He's now applied to Broward College, and he intends on attending Broward College in summer B. He lives in Miramar with his mom. His mom is a caretaker. So, Judge, that's why I was going to ask for an ROR. But in the alternative, if the court doesn't agree with that, then we're asking for the $1,000 bond.
Well, the court was going to impose a $5,000 bond based on these allegations, so I'll take the state's offer of $1,000 bond. And no return to this location. Michael Sapio.
Mr. Sapio, come on up, please. Mr. Sapio. He's here, man.
All right, Mr. Sapio is before the court. Count 1 is grand theft auto, count 2 is possession of heroin, and count 3 is driving while license suspended. And the court does find probable cause.
Nothing to add at this time, Judge.
Your Honor.
Yes.
Your Honor, the state is going to, the state is going to be seeking a bond increase on count 1 to $2,500. Additionally, Your Honor, the state would note that Mr. Sapio is out on bond. He was arrested April 21st for possession of methamphetamine, possession of cocaine, theft, possession of cannabis, and possession of drug paraphernalia. He's out on a $2,300 bond. The state would be seeking a bond revocation in that matter.
They've
Even-
already been surrendered.
Well, they've been surrendered, but Your Honor, that's just what his bondsman chose to do. If the court is inclined to grant the state's request and revoke, certainly the court can do that, and is not bound by his bondsman's decision.
Judge, the drug offense, it's not filed, Judge. I'm asking at this time the court to leave the bond, and the bond's currently set in place.
He was just arrested 2.5 weeks ago.
So the previous arrest was 2.5 weeks ago?
April 21st, he was released April 23rd upon posting his bond.
And all of the charges are bond, drug charges on the previous arrest?
They all, there's one count of theft.
Okay. All right, so Mr. Sapio is out on bond. It's the same charges. It's theft and it's drugs. And he's now before the court again for grand theft auto and possession of heroin and driving with a suspended license. So what's that case number on the previous case?
195163 CF10A.
All right, so the court will, I am going to revoke his bond on case number 195163 CF10A. And as to the new arrest, the standard bonds will be in place.
Your Honor, are you ordering that he be held no bond on the pending case?
Yes, I'm sorry.
I'll
Yes.
prepare an order for the court.
Yes. Marcus Nagel?
Mr. Nagel's approaching, Judge.
All right, Mr. Nagel is before the court. Count 1 is possession of methamphetamine. Count 2 is possession of drug paraphernalia. And count 3 is misuse of 911 or emergency system. The court does find probable cause.
Judge, we're going to be requesting that the court consider releasing Mr. Nagel on pretrial release on these nonviolent offenses. My understanding, speaking with Mr. Nagel at this time, no one's going to be able to post his monetary bond. He lives locally here. He's been living in the same premises for about 7 years now, Judge. did advise me he's currently looking for work. He will be returning to court. So, Judge, I'm asking at this time for the court to consider releasing Mr. Nagel under supervision with pretrial release.
Your Honor, no, please go ahead.
Oh, yeah? Okay.
No, nothing further, Your Honor.
All right. The court does find probable cause, and Mr. Nagel's bond has already been posted.
You said disbarred attorney.
All right, Edward Jones.
Judge, Mr. Jones approaching. He declined service to public defense. What page did I tell you, sir?
All right, Mr. Jones, you're before the court. Count one is a misdemeanor capious matter, and you do have a $250 bond attached to that. On count two is a violation of felony probation. That's a no bond hold, and you'll be before your division judge, your felony judge, tomorrow at 8:30. Okay?
Yes, ma'am. How does the bond work for the first case, ma'am?
Well, if you post the bond and you have a no bond hold, you still won't be going anywhere, and you'll stop getting credit on the case that you posted the bond.
Okay, but I'm saying, like, if I see my judge tomorrow, what do they do with the case that I have the bond on? Will they let me see that judge or no?
I have no idea. You have to talk to your attorney and see if they can get you to court, okay?
Thank you, ma'am.
You're welcome. Carrie Lubin.
Approaching, Judge.
All right, Mr. Lubin, you are before the court. Count one is retail theft. Count two is resisting officer without violence, and count three is a felony violation of probation, which has a no bond hold. You will be before your division judge tomorrow at 8:30. The court does find probable cause, and your bond on count one is $1,000. Okay? All right, Robert Pellegrino.
Mr. Pellegrino is here at main judge approaching. Mr. Pellegrino, come on up, please.
Mr. Pellegrino. Good morning, sir. You are before the
Good morning.
You're before the court on a grand theft charge, and the court does find probable cause.
Judge, at this time, nothing to add from the defense.
The state would be seeking a $5,000 bond. Mr. Pellegrino is out on bond right now for a filed grand theft from 2018. The allegation in that case is he stole a cell phone from the victim at the Seminole Classic Casino. Note the allegations here. In this case, he is posing as the customer, stealing a cell phone. In 2009, he was convicted of burglary of a dwelling and grand theft, sentenced to 56.5 months state prison. 07, felony battery, great bodily harm with a violation of probation, sentenced to 56.5 months state prison. The state would also be seeking a revocation on his pending grand theft.
Okay? What is that case number, please? On the other grand theft. And Mr. Romero, I'll hear from you while I'm waiting for that.
Hold on. I'm sorry, Your Honor. The case number is 18-7932 CF10A.
Judge, at this time, I'm just going to ask the court not to take any action on the case that he's currently out on, Judge. My understanding is Mr. Pellegrino is basically takes care and looks after his mother, who's elderly. She has medical issues. She depends on him to make sure that goes to her documents and reminds her as far as her medication. Considering her nonviolent offenses, Judge, that's why I'm asking at this court to consider not taking any action. If the court is going to consider taking any action, I would ask the court, rather than holding Mr. Pellegrino no bond, which is the most severe sanction this court can impose, I'd ask the court to consider less restrictive, potentially releasing him under supervision, a pretrial release with a monetary bond, or an ankle monitor and the alternative, Judge.
How much bond did he post on the first, on
One
the
moment, Your Honor.
other case?
Your Honor, from what I can tell, it looks like he posted a $1,000 bond, but I would note, it appears that that bond was posted before he even had a first appearance for a judge to review what the bond should be.
All right, based on the allegations, it's another theft charge, another grand theft charge. So on case number 18-7932 CF10A, the court is going to revoke his bond, and he'll be held no bond on that case. And as to the new arrest, the bond will be $1,000. Okay? Devin Clark,
That's North Broward, Your Honor.
okay? All right, Mr. Clark, you are before the court. Count one is selling cocaine within 1,000 feet of a school or park. And count two is driving while license suspended. Third or subsequent offense. And the court does find probable cause. And does anyone wish to be heard?
Yes, Judge. Initially, from what Mr. Clark tells me, he does have a valid driver's license. So I don't know if the state can check that out or not, but that's what he advised me. And Judge, he's never going to be able to make a $25,000 bond. He has been a resident here of Florida all of his life. He's been living at the same location for the last 10 years with his children, ages 13 and 6. He works as a landscaper. From what he advises me, he has not had any trouble with the law in the last 10 years. What I would consider asking the court to do would be to reduce Mr. Clark's bond to $5,000 on count one and place him on pretrial release.
Your Honor, the state is asking you to keep the bond as is set by Judge Hussein and all the special conditions that Judge Hussein laid out in page 2 of the arrest affidavit.
All right. The court finding probable cause, I am going to leave the bonds in place, as well as all the special conditions that are listed in the arrest warrant. Okay, so on count one it's $25,000, and on count two it's $5,000. And
You have to judge. Excuse me, Judge.
yes, sir.
I got my car in the tow and I got my kids at home. I can't pay that much bond.
All right, sir. Then you need to talk with your attorney, and then you can present a motion before the judge with all the necessary information. Okay?
Like, how would I do that? Because, like, I got my kids at home and they can't go to school because my car is in the tow and stuff, and I'm the only one can get it out the tow and all that.
Sir, you have to speak with your attorney. Okay?
So how can I get out? Like, what do I have to do to get out of jail?
You have to speak with your attorney about posting your bond.
How do I speak with him?
Mr. Reedy, does the PD office represent?
We will be.
Okay.
So I'm sure that there'll be somebody up to see you very shortly, sir. And you're entitled to a hearing in front of your division judge to address your bond issue.
And how long would that be before I can see the judge?
That I can't say. Hopefully very soon. We try and see people within a week of their arrest. And your attorney then can set up a bond hearing in front of your division judge, but Judge Powell has already ruled here this morning.
And I have a valid license, so how can I have a bond for no license and no license valid?
Okay, sir, we're gonna move on, and you need to speak with your attorney, okay? Well, the state has an answer for you as to your
He
license.
did get his license restated. That was after this incident. His
Okay.
license was suspended at that time.
Okay, all right. Okay, let's go to Otis Smith.
Don't worry about that.
Mr. Otis is here, Judge, at Maine.
Mr. Smith, you are before the court. Count one is driving while license suspended, and count two is an expired tag less than 6 months. That's not for magistrate. The court does find probable cause.
Judge, we're gonna be asking that the court consider releasing Mr. Smith on pretrial release. He's been here his whole entire life. He's 50 years old. He was getting disability. He was getting approximately $600. His assistance was cut off, I believe, a month ago. From what he advised me, his condition improved, and at this time, he is currently looking for employment. He lives in Fort Lauderdale with his brother. Unfortunately, his brother's not in a financial position to help post his bond. He collects disability, and that's his sole source of it. Judge, right now, as you can see, he has no funds to bond as far as $150 go. He does say he has prior contact with the criminal justice system, but it's been a number of years. So that is why I'm asking this court to consider releasing Mr. Smith on pretrial release.
I don't have an objection.
All right,
to that,
Mr. Smith, you'll be released to pretrial supervision. The attorney's handing you the information. Sir, you must report to the pretrial office within 24 hours of your release. If you fail to do that, a warrant will be issued for your arrest. Do you understand that, sir?
Yes.
Okay, good luck.
Good luck, sir.
Damon Nicholas.
He's approaching, Judge. You share with me?
All right, sir, you are before the court. Counts 1, 2, and 3 are grand theft charges. Count 4 is resisting without violence, and count 5 is a misdemeanor capious on a possession of cannabis charge. Okay, the court does find probable cause. Does anyone wish to be heard as to bond?
Yes, Your Honor. There is a no bond capias that's on a pending case. Oh, we're asking that you have his bond revoked on a pending case. It's 1954. I'm sorry, I misspoke, Your Honor. 193973 CF10A. It just hasn't updated in the system yet. And the charges are grand theft, possession of cannabis, and resisting without violence. It was scheduled for arraignment on Monday. However, Mr. Nicholas did not appear. And Judge Scheer issued a non-bond capias. It just, like I previously stated, it just hasn't refreshed in Odyssey as yet.
Okay.
And to add, he has a pending criminal mischief case for Judge Gottlieb.
All right. As for the new charges before the court today, I'm going to leave those standard bonds in place. And then as to the other felony charge, where what, he failed to appear for arraignment?
Yes, Your Honor. Just because it happened on Monday, I don't know that.
All right, so then I'll revoke his bond on that case, and he'll be held no bond on that case. All right? Yes.
193973 CF10A.
All right, Jacob Montoya.
He's here present, Judge Maine.
All right, Mr. Montoya is before the court on a robbery with a firearm charge, and the court does find probable cause. I'll hear from the parties as to bond.
Your Honor, the state at this time is seeking a $25,000 bond and pretrial GPS. And no return, no victim contact, no return to the location.
Okay.
Judge, we're gonna be requesting a $10,000 bond, Mr. Montoya. My understanding, Judge, he has limited contact with the criminal justice system. 20 years old. He's been here his whole entire life. At this time, he's currently looking for employment. Right now, he is going to school. He goes to H.D. Perry, completing their GED program. He lives in Miramar with his mother and his 1-year-old daughter. His mother's the person that helped post his monetary bond. She is a school teacher, so she's not going to be able to afford what the state has suggested, Judge. Considering his limited contact with the criminal justice system, strong ties to the community, that's why we are asking for a $10,000 bond on Mr. Montoya's behalf.
And Your Honor, just so the court's aware, his, and this is also part of the reason why the state's requesting the bond his contact really isn't limited, as he's only 20 as a juvenile. He's had numerous priors for multiple burglaries, felony theft level offenses. Who was that?
The court does have concern for the community based on these allegations where the alleged victim was showed up via a Let Go app to sell an iPhone. And when the person showed up to sell the phone, they were held at gunpoint, and the phone and wallet, well, they took the phone, the wallet was not taken. And so the court does have concerns for the community, and based on that, I am going to impose a $25,000 bond. And I am also going to add a level 2 GPS anchor monitor, should Mr. Montoya post his bond. No victim contact and no return to that location. Do you understand that, sir?
Yes, ma'am.
All right, good luck. Jonathan Wilkins.
Please hear our main judge.
All right, Mr. Wilkins is before the court. Count 1, possession of cannabis 20 grams or less. Count 2, delivering cannabis within 1,000 feet of a school. Count 3 is aggravated fleeing with injury or damage. Count 4 is resisting officer without violence. Count 5 is failure to stop or remain at an accident involving non-life-threatening injury. Count 8 is unsecured tag. Count 7 is following too closely. And count 8 is resisting officer with violence. The court does find probable cause as to all those counts. And I'll hear from the parties as to bond.
Judge, I didn't see any delivery of cannabis within 1,000 feet of a school in this probable cause affidavit.
Well, the first line of this May 7th report says that the above offense list was committed and that this location is within 1,000 feet of the Coconut Creek High School campus.
And even though it might say on the booking and the findings delivery, that's not what's page. That's not what the officer charged him with. I would argue the probable cause affidavit should control, and the offense charge that says possession with intent to sell or deliver.
I don't know how you can assume that if someone that was in possession with intent to sell marijuana that they also intended to sell it within 1,000 feet of a school when there's nothing in the probable cause affidavit to indicate that he sold anything at all.
I think the officer can make an argument, and this will be, I think, a question for the jury. I know he claims he bought 12 individually packaged bags of marijuana, but I think an argument can be made that that is packaged for sale.
Assuming that that's true, that does not place any sale within 1,000 feet of a school.
Your Honor, it doesn't have to be a sale within 1,000 feet. It's possession with intent to sell or deliver within 1,000 feet.
But we're being asked by the state to make this leap of faith that even if Mr. Wilkins was in possession of marijuana and had the intent to sell it because of the individually wrapped bags, that there was also evidence that he was going to sell it within 1,000 feet of a school, and there's no evidence of that at all.
Your Honor, all there needs to be is that he comes within 1,000 feet while in possession with intent. Your Honor, he went within that distance. He was in possession. There's evidence to indicate that this was not merely possession for personal use.
All right. The court's finding will stand. As to bond?
Yes.
Your Honor, at this time, the state is asking for charges 3 to be, the bond to be set for $10,000, and for charges 5, bond to be set for $5,000, and for case, and he has a pending case, and we're asking for if the court should revoke his bond on that pending case. And it's for possession of cocaine.
What's going on this morning?
Possession of cocaine with the intent to sell and deliver. And that case number is 18-13341 CF10A.
What are the charges on that other case?
Possession of cocaine with the intent to sell and deliver.
And how much bond is he out on that charge?
One moment, Your Honor.
Again, Your Honor, he posted a $2,500 bond, but it appears that that was posted prior to his first appearance.
All right. As to the new arrest, the court does find probable cause. Count 3, the court will impose $5,000, and on count 4. On count 5, the court will impose $1,000. And count 8, $1,000. And then the other bonds will remain in place. And as to, can you please state the case number of the previous case again?
Yes, Your Honor. It's 18-13341 CF10A.
Judge, may I have one moment to consult with my colleague?
Okay.
Yes, Judge, we would object to the state recommending a bond revocation on Mr. Wilkins' 2018 case, so we're entitled to at least 3 hours' notice, if that's what they want to do.
recent case law from the Fourth DCA.
All right, let's do this. And the motion can be brought in as division as well, so let's just move on. I'll take no action on that. Evelyn Alsimi,
He's here, present, Judge.
Mr. Alsimi is before the court on count one, trafficking cocaine 20 grams or less. Count two, possession with intent to sell, manufacture, or deliver cannabis within 1,000 feet of a school. Count three, trafficking in MDMA. Count four, trafficking in heroin. Count five, possession with intent to sell or deliver THC. Count six is possession of drug paraphernalia. And count seven is resisting officer without violence. The court does find probable cause. Anyone wish to be heard?
Yes, Your Honor. One moment. Okay, yes, Your Honor, I'm going to be seeking a bond revocation. Mr. Alcime is currently out on bond for possession of substituted cathinones and possession of cannabis with intent to sell or distribute at a near designated area. Your Honor, I would note that arrest actually occurred at the same exact incident location as this matter. Your Honor, I would also refer to, and given this court's authority to grant the state's motion, Johnson v. State of Florida. It's a fourth DCA case from May 1st of this year, cited at 4D19-826. In that matter, Your Honor, the state sought a bond revocation in front of the first appearance judge. Now, the first appearance judge declined, then the state sought a revocation in front of the assigned judge, which is granted. The defense sought a writ that the assigned judge did not have the authority to grant the request after the first appearance judge denied it. The point I'm making is, Your Honor, the fourth DCA nowhere in the holding states that it was that the first appearance judge did not have the authority to grant or decline the state's request. This is a revocation. It is not a modification, which is what Mr. Romero is referring to. Those rules deal with a modification request.
The court did read that, I did read that case.
I think that we should
2 days ago.
notify Mr. Alcimi's private attorney, Carter Hellstrom, before any action is taken on his bond on that case.
He has a private counsel on the
Yeah,
other case?
I just looked it up just now, and yes, he does.
All right. And since his attorneys, does the public defender's office represent him on this new arrest, or will be?
Well, I don't know.
On the new offense, Judge, he did fill out a financial affidavit.
Okay. All right, so, then the court will not take any action on the other case since he has private counsel who's not present.
Understood.
And then, any argument as to the bond on,
Your Honor, the only thing, I'm fine with the bond amounts, but since the court is not going to be taking any action, which I understand, I would be requesting a GPS monitor in addition, so.
Judge, from what Mr. Alcima advised me, unfortunately, at this time, he's advised me he's homeless, Judge, so he's financially indigent, so there's no way he's gonna be able to come up with these bond amounts. So I'd ask you to take that into consideration.
All right, looking at the charges, and I am going to add the GPS in addition to the bonds, the standard bonds that are in place. Yes. Juan Diaz Joseph.
He's approaching, Judge. Oh, yes, private counsel? Oh, Judge, I've been advised Mr. Joseph has private counsel on this case.
All right, is that Meredith behind the screen? Who's behind the screen? Bring him back for just 1 minute. I'll take a break and talk with them for a minute. There's so many of them, I just.
We were gonna go see a trial in front of Judge Orlando at 10:30, so that's why I was,
Okay.
I didn't mean to interrupt.
No, there's no interruption, that's fine. All right, while they're coming back in, Mr. Joseph, you're before the court for license plate, possession of counterfeit license plate. Count 2 is a learner's driver's license violation, which is not for magistrate, and count 3 is a no bond hold on a felony violation of pretrial, also not for magistrate, and you'll be before your division judge tomorrow at 8:30, and the court does find probable cause.
Judge,
Okay?
I did speak with Mr. Joseph's attorney, Tom Morse, and I
Okay.
advised him of tomorrow's court date, so he will see you there tomorrow morning, Mr. Joseph.
All right, sir, good luck. I'm gonna take a brief recess to speak with the students for just a minute.